Pregnancy discrimination. As a new mom, I know how scary it can be to disclose your pregnancy to your employer. Pregnancy discrimination is illegal in California, and this can take many forms. For example, this could take the form of retaliation after you disclose your pregnancy. Perhaps your employer reduces your hours, gives you a demotion, takes away your responsibilities at work after you disclose your pregnancy. That could be a form of pregnancy discrimination. Another protection that pregnant employees have in the workplace is the right to request accommodations for their pregnancy-related condition. For example, if you have severe morning sickness, if you develop gestational diabetes, if you develop preeclampsia, you're entitled to request reasonable accommodations for these conditions. You could request time for your prenatal appointments, an alternative schedule, additional breaks to cope with some of these conditions. The employer is required to engage in the interactive process with you to determine if there's a reasonable accommodation that can be made to help you perform your job. There's two types of leave that employees are entitled to when they're pregnant in California. The first is pregnancy-related disability leave. So this is leave that you can take either before or after childbirth because you've developed a condition related to your pregnancy. For example, like we talked about earlier, the severe morning sickness, preeclampsia. It can also just be simply to recover from giving birth or having a C-section. Employees are entitled to up to 4 months of protected leave under the California Pregnancy Disability Leave. You don't have to have worked for your employer for any amount of time in order to qualify for this leave. The last type of leave that employees are entitled to is leave under the California Family Rights Act. This is your typical baby bonding leave. Employees are entitled to take up to 12 weeks of leave to bond with their new baby after birth or adoption if they've worked for the employer for at least a year and at least 1,250 hours in that last year. For both of these leaves, the leave under the pregnancy disability leave and leave under CIFRA, if your employer retaliates against you for taking leave under either of these protections, then that could also be a form of pregnancy discrimination, and you could be entitled to compensation for the harm that you've suffered. If you think you've experienced discrimination, or if your employer has retaliated against you for taking your protected leave, if your employers refuse to grant you accommodations because of your pregnancy, you should give us a call here at Miracle Mile Law. We'll walk through your case, we'll understand the facts, we'll hold your hand every step of the way, and we'll help you understand what your options are as you navigate this very challenging time.